Good afternoon, everyone, and welcome. We're going to begin our bail release work group meeting. And while we do not have a quorum, we're going to begin anyway, and mostly because I know everybody here has got, you've got your next thing stacked on top, just to be respectful. But also, I suspect we'll have a few people drop in, and what I would just ask is we scoot over and make room and give them a nameplate, and we'll get going. What I'd like to do, if it's okay, to just begin the meeting, if we could have folks just introduce themselves, and may I start on your side, Judge? And that it's also a good way to know, Judge Lucas, if we all know where all the buttons are.
Good afternoon, Patricia Lucas, Superior Court.
Good afternoon, Zakia Afrin, Domestic Violence Advocate at Maitri.
Good afternoon, Damon Silver from the Public Defender's Office.
Gary Hersig, County Executive's Office.
Aaron Johnson, Pretrial Services.
Laura Garnett, Probation.
Cindy Chavez, member of the Board of Supervisors.
James Williams, County Counsel.
Jeff Stanley, CEO and President of Bad Boys Bail Bonds.
Raj Jait of Debug.
Yeah. Jerry Schwartz, Civil Rights Representative.
Thank you. So we'll begin to see if first, we'll start if there are any public comments, and this is for anybody to speak to an item that is not on the agenda but within the purview of the committee. Seeing none, we're now going to move on really to the bulk of our discussion today, and this is to receive a report relating to the implementation of recommendations contained in the Bail Release Work Group Final Consensus Report on optimal pretrial justice and relating to legal and legislative updates in the area of bail and pretrial reform. And so I'm not, Gary, are you getting us started?
Yeah, I'll go ahead and kick it off. Before getting our presentation, I just wanted to start with a brief overview of the materials before you today. The legislative file contains updates on new legal developments in the areas of bail reform that have occurred since our last meeting. It also has updates on several outstanding bail and release work group recommendations. Also, you have updated memos from the Sheriff's Office on their efforts regarding several of the recommendations. And finally, you also have an attached updated recommendations matrix, which has been modified to include information about how SB 10 may impact some of the recommendations. So Adriana from the County Counsel's Office is going to start us out today with an update on some legal case law changes since our last meeting.
So if I could just, from a process perspective, if I could ask everybody, if it's okay, I think, to ask questions so the presentation doesn't go so long that you can't remember your question. But particularly if you have something that's a clarifying question, make sure you turn your light on and just ask it. Is that all right with the staff? Just from a...
Yes.
Good. All right. Thank you.
Hi, I'm Adriana Benedict, County Counsel. Since the Bail and Release Work Group last met, a number of legal and legislative developments have altered the landscape for the recommendations that were originally made by the Bail and Release Work Group. So I'd like to provide a brief overview of those to start off our presentation. Most significantly, of course, SB 10 transforms the pretrial system in California by eliminating monetary bail and requiring that pretrial release decisions be based on an individual defendant's risk levels with respect to public safety and failure to appear. At the end of this presentation, we will go into some of the specific provisions of SB 10, but the main impacts, just to note for now, will be on the Office of Pretrial Services. Although SB 10 was modeled on much of the work done by our Office of Pretrial Services, it will require some changes and updates to current practices, such as the processing and release of most misdemeanor offenses within 12 hours, the use of a risk assessment tool selected by the court, and the use of risk levels designated to be used with that tool by the Judicial Council. The California Bail Agents Association, as I'm sure many folks have heard, has started a referendum campaign to withdraw SB 10, and if sufficient signatures are collected in that campaign by the end of November, then SB 10 would be put on hold until at least November 2020. Regardless of when SB 10 is implemented, it may also be subject to legal challenges which could further delay its implementation. Independent of SB 10, a few cases challenging different aspects of monetary bail have been percolating through the courts. Two of these involve California Court of Appeal decisions that were issued in January of this year. First, the California Court of Appeal held in re Humphrey that a trial court cannot set bail without inquiring into a defendant's ability to pay and without considering less restrictive alternatives to monetary bail. And a trial court, when setting bail that a defendant cannot pay, must make specific findings related to public safety threats. As a result of in re Humphrey, trial courts have been since January holding what have been called Humphrey bail hearings to make the required findings. The California Attorney General did not appeal in re Humphrey. However, the Supreme Court decided to review it of its own accord and ordered the San Francisco District Attorney to address the arguments made in the case. In its brief, the San Francisco District Attorney agreed that due process and equal protection require a court to consider both a defendant's ability to pay and the alternatives that may be and to consider less restrictive alternatives to monetary bail before ordering bail for a defendant. According to the San Francisco District Attorney, the only issues that remain in this case are under what conditions the California Constitution authorizes pretrial detention. Many amicus briefs were recently filed in support of Mr. Humphrey, including one by the California Association of Pretrial Services, and one amicus brief was filed by the California Bail Agents Association in support of neither party. And the California Supreme Court has ordered supplemental briefing in this case to address the impacts of SB 10. Another case currently pending before the California Supreme Court is in re Webb, in which the Court of Appeal found that trial courts have no authority to impose additional release conditions on defendants who have posted reasonable bail for a felony offense. According to the court, when felony defendants post the scheduled bail amount and neither the court nor any law enforcement officer suggests that an increased bail amount is appropriate, imposing additional conditions of release may violate the defendant's right to be free from unreasonable searches and seizures. The California Supreme Court has also ordered supplemental briefing, in this case addressing the impact of SB 10. Lastly, a federal class action filed in the Northern District of California is challenging the constitutionality of San Francisco's use of its bail schedule under the Equal Protection Clause. The California Bail Agents Association, instead of the City and County of San Francisco, is defending the case called Buffin v. City and County of San Francisco. Trial in this case was set for September, narrowed down to the issue of whether there are plausible, less restrictive alternatives to the bail schedule that achieve the government's compelling interest in getting defendants to appear in court. However, after SB 10 was passed, the plaintiffs filed a notice with the court stating that SB 10 largely mooted the issues in the case because it would abolish the use of bail schedules and because it demonstrates that there are plausible, less restrictive alternatives to monetary bail. The court subsequently vacated the trial date and is currently considering cross motions for summary judgment. The plaintiffs in the Buffin case have also asked the court to revoke the California Bail Agents Association's status as the de facto defendant in the case. And that wraps it up for the legal developments. So unless there are questions, I'll hand it back to Gary for updates on the recommendations.
So are there questions? No, I have one. Oh, do you want to go ahead, Jeffrey? Do you go by Jeffrey?
Jeff.
Jeff,
Jeff
okay.
is fine, or Jeffrey. Either one. Thank you. I know there are a few other cases that were not discussed. I know there's a couple of federal cases that have been filed, and also other state cases that have been filed in argument in favor of the constitutionality of surety bail. And I know we haven't addressed that here. I know there's quite a few other things going on. You mentioned the referendum. I know we have roughly 350,000 signatures currently. We need 360, and half the time is ran. So I think we would sufficiently have enough signatures on SB 10. And then again, the constitutionality cases that are being heard. I know our state constitution strictly addresses surety bail, that everybody should have a right to sufficient surety. And SB 10 in specific does away with bail. So I feel very confident that the courts will see in favor, but then again, you never know. And depending upon what court you end up in, I believe we will have some protection at the federal level. So.
And by protection, you mean?
The constitutionality issue.
Okay. Other questions? Did you, James, want to add anything? I don't know. You were leaning for your light. That's why I asked.
Yeah, I was just going to make the comment rather than the question that these are pretty significant foundational developments since we last met as a group and we were considering recommendations. As I think is reflected in some of the later materials in terms of status on different items, adjustments have been made in light of some of these very, very significant developments. And I think we have to think about each of those recommendations given that, but also given the uncertainties that exist. You know, SB 10, certainly with the referendum and so forth, but even that aside, the other court cases are a pretty foundational shift in approach.
Any other questions or comments on this side? I have one very broad one, but if it will get answered in the presentations, I'm fine with that too. And that is that at some point, I think there would be value in us just walking through just very, very concretely those things that, irrespective of the drama that happens outside the county, that the programs and the approaches that we're still going to be taking and can be taking. And the reason I say this is that I for one, am very concerned about what I see as sort of blunt object approaches to solving something that's a pretty intricate problem. And I'm nervous both about, I'm concerned about even some of the legislation relative to state referendums. And I personally think referendums, state, anyway, not to put too fine a point on that. So at some point, and if it won't be revealed today just based on the way the presentation is outlined, I think there is value when we do a report back to the board to start with, here's all of the things that are up in the air, but here are the areas that that we think will be unaffected. Here are the areas where we need to have concern, and here are some recommended approaches. So, okay, with that, I'm going to keep letting you go on with your presentation. And again, oh, sorry, Raj, go ahead.
Yeah, just dovetailing off of what Supervisor Chavez was talking about. I also agree we're in this dramatic historical shift, potentially, around bail and pretrial justice. And as some of you may know, along with my colleague to my left here, Jerry of the ACLU, we are large proponents of SB 10. We're actually, my organization was the original co-sponsor of the bill up until the last few weeks when essentially the author switched out the bill with an entirely different version that got signed by the governor. I bring that up because after the shock wore off, I think the position that we're in, and I think this body is well positioned to take on, is to imagine SB 10 as sort of a state basement. And it leaves itself vulnerable to either maintaining the same levels of pretrial incarceration or increasing it through its preventative detention apparatus that is built in. But that doesn't mean that Santa Clara, who's always looked at as a leader not just statewide but nationally, has to lower our expectations to the basement of SB 10. So what I would suggest that this body could be responsible for, if SB 10 does land on us in November 2019, is be prepared to have an elevated understanding of what our pretrial justice system should look like, and to think of SB 10 as a lower standard and Santa Clara having a higher standard. So what I'd be asking is that our county have an explicit goal of pretrial decarceration, identify that number, and then see how we could essentially back into that number by influencing community release projects and pretrial services, cite and release, but essentially have a real target number, because what SB 10 essentially does is it leaves a tremendous amount of malleability and flexibility to the local court actors. So some of these terms that was described in the bill have no actual definition. So there are consequences of being labeled high risk in the pretrial detention status, but no definition of what high risk means. So what that means is you could calibrate some of these criteria to see who's released. And Santa Clara could calibrate our numbers in such a way that we ensure that we continue down a road towards decarceration. And that would be my suggestion for this body.
Thank you. So I'm going to just let the staff continue on the report. I know you have more slides, and then we'll, at each area, we'll jump in again. Gary?
So I just wanted to go over a few of the outstanding recommendations from the original bail and release work group recommendations to the full board that ended up approving 16 of the 18 recommendations. First, I wanted to talk about the Community Bail Fund and the Community Release Project. Administration released both an RFI and followed up with a RFP for both of those recommendations. Unfortunately, we did not get any responses to the RFP, despite having a pretty robust group of vendors at the original kickoff for the RFP. When we surveyed the vendors, what they indicated was that it was too much capacity for them internally to take on a countywide program. They also, regarding the Community Bail Fund, expressed concerns over SB 10 and the elimination of commercial bond, and that recommendation would be moot once SB 10 is implemented. So that was another reason for them not applying for the Community Bail Fund RFP. Regarding the EMP release program through DOC, those program rules are still pending development through the Sheriff's Department and the Department of Corrections. However, I do want to advise the Bail and Release Work Group of a new electronic monitoring release program that just started last Monday. If some of you remember some of the work on the jail reform efforts by Dr. Jim Austin, he indicated that the #1 impact population in our jail was those individuals serving 6 to 9 months on sentences in our county jail. With that in mind, and I want to compliment David Angel, I don't see him here today, but he really took that to heart and proposed a program of creating a home detention program for individuals that are charged with crimes that would normally serve 6 to 9 months in custody. And we looked at data for 2 years worth of data, and we worked with the court, the public defender, probation, and pretrial over a period of time to develop this program, which the court approved, and we started last week, and I was just told we have 2 releases already on that program. This program will allow individuals to receive custody credits while they're in the community on electronic monitoring. They'll also receive services through reentry services and others, county and non-county affiliated programs. And once a case is adjudicated, our hope is that the court will not sentence them to additional custody time, but go ahead and if they are convicted, put them on probation, and the supervision would then transfer directly to probation. If there is any more remaining custody time needed to be served, they would serve that on electronic monitoring. So we started with a 100-person pilot program. This has the potential to have great savings for the county in the use of jail bed days, considering these individuals would typically serve a 180-day sentence in jail. So again, it just started last week, so more to come on that in the future. The validation of our DARA tool, the RFP for the validation study is tentatively scheduled to be before the Board of Supervisors on October 30th, 2018. Once that RFP is released and a vendor is selected, we anticipate the study taking about 6 months, depending on the data needed by the vendor for that. But we're looking forward to seeing a local validation study done on our ODARA tool. Regarding in-field pretrial supervision, there's no new considerations on that. However, if SB 10 becomes law, an exception is made in Santa Clara County to not use peace officers for pretrial supervision. However, I think that's something we should revisit when SB 10 becomes law and the level of individuals that could potentially be released under a new law. I'm not going to go through every bail and release work recommendation, but I just want to note that there is a matrix attached to the legislative file today that has updates on where each recommendations are in the process. There's also data on some of them. For instance, the cite and release policy that we changed in October of 2017 has resulted in more individuals being cited and released in the county, and there's data in the sheriff's memo that reflects that. So, go next slide, please. So I wanted to move into SB 10 impacts, but before I do, I wanted to just ask if there's any questions on the recommendations.
Raj? No, go ahead.
Okay. Yeah, I had a particular, Gary, we've been having email conversations. I know we've been talking to different folks at County Council. So just to kind of update the rest of the group and see maybe where we could head, and this could be a conversation we would have offline or separately. But as a way of a background for the Community Release Project recommendation, so folks remember that was an idea that DBUG brought to this group way back in the day, and this group approved the concept of it, and then it got forward to the Board of Supervisors, and you all unanimously supported all the recommendations presented, from what I remember. So then it went into this RFP situation, and so DBUG reviewed the RFP and decided not to apply for the RFP, and the reason being is what we saw reflected in the RFP was pretty different in small but substantive ways from what we presented. More or less, without getting to the weeds, that there were sort of reporting conditions if a person didn't sort of perform or participate properly in the community release program project, then that community release project outlet would then have some sort of reporting conditions. And it seems subtle and small, but it was a major philosophical difference from what the idea of community support was, to make a distinct mark between support versus surveillance. So what we didn't want was essentially pretrial light or probation light. We wanted something really with autonomy about the community, because the idea is if we could just offer some measure of support, you're going to see the numbers bear out that people return to court and they don't pick up new charges and they abide by their conditions and that sort of thing. But in response to that email that we explained, it turned out that we were ineligible to apply to begin with. There was some difference of communication. I didn't fully understand that at first, and then I got notified later, which saved me a good at least week of applying, so I appreciate that I didn't. But where we are now is, look, our community, meaning DBUG, fully believes in this concept of community release. I think it's the future of pretrial justice. I think it's the third option outside of money bail and system supervision that this country needs to go to for pretrial decarceration. So with that said, we would propose that this county allow Debug to basically pilot community release project through the terms that we described that was originally okayed, and not have us, we won't charge the public or the county a penny. Let us pilot it. We'll get our own independent philanthropic dollars behind it. And then we could present our numbers and our data back to this group so that you could see if this sounds like something that the direction the county wants to go in.
So can I ask, this is, I'm glad to see no lawyers have jumped forward to say stop talking. So I'm just going to keep doing that until one of you does come out of your seat. I think, actually, I read the letter you sent because you copied me on it. And it's funny because it is what I thought I voted on is the staff's interpretation. And so that is the point I want to raise there is that I do think that in some respects we had thoughtful, meaningful conversations here that didn't get talked down to the weeds because we didn't do any kind of subcommittees or any kind of work that really looked at the unfolding of the process in my mind in a deep enough way. And so in some ways when I saw your letter I was thinking, what was he thinking? And then I thought, oh, that's right. Like I get, like we got to this one level where we were all in agreement, and then there was this other level. Yeah. And the other level I remember from your note was, look, we don't want to report when someone's not having success. Like, don't put us in that situation. We're trying to build trusting relationships. Don't make us rat people out. And I mean, that's the way I read your letter. Was that accurate?
Yeah, I don't know if I used that language.
No, you didn't. I was thinking about the way, well, anyway, I was just thinking about the way I interpreted it. I was like, oh, I get it, because this is about building meaningful relationships in the community with a trusted nonprofit that would dramatically change your relationship with the community if you were in that situation. Yeah. I think the way I was thinking about it was that I was trying to find a mechanism for creating enough support to the courts to make the courts feel more comfortable with taking a step that was a little bit ahead of where most people are yet. So when we voted on it, I really was thinking about the fact that we wanted organizations that could, not necessarily even to get people in trouble per se, but really help us understand what's the right long-term, when you're looking at aggregate data, what's the right kind of support and dosage that the average person needs to be successful? Yeah. And how do we understand that how do we understand the very best way to do that unless we understand the whole data set? Yeah. And then we're able to ask people, well, what happened here? So what I would want to recommend is that with staff that we have some deeper conversation about, including with the courts, who falls into what bucket of support and services, because that therein may also lie part of the opportunity, because I think we were trying to figure out initially, at least I was, what's the most appropriate group for this type of support. And frankly, there may be other folks as we learn more with our tools that we think that in general this pool of people needs a different set of supports. So if I could, what I'd want to recommend is not so much that we make a recommendation, but that we ask this group to create a subgroup that can actually wrestle some of these subjects back. I'm comfortable, if you all are, hearing those back here so that we really can have a deeper dive on it, and then make a recommendation to the board that's a little more, where we're all a little more clear on the concrete elements of each. Because I think you're right. We both got to this level, and then I took it one way, and I think I took it the way the staff took it. And then when I saw your note, I thought, oh, we didn't dot the I's and cross the T's. What are your thoughts about that? And then I'll come back to you, Jeff, in a minute. Jeff, yes. If I could just finish, I wanted to ask Raj, and then I'll go to you.
Oh,
yeah.
I'm sorry.
No, you're right next to each other, so I apologize. Go ahead, Raj.
Yeah, I'm good with like having further conversations with staff and whoever, and I do think this is the direction that every county needs to go, and so the way I would read or respond to sort of I think very natural questions about how do we even know what supports people need is that would actually be part of the pilot, which is like the Community Release Project group. We could still track like what's happening, and actually that'd be the purpose of the first year of a pilot is to say X percentage of people say they have challenges with transportation. X number of people say that they can't get to court because of these reasons, housing. And so we'd be able to track that data. So it wouldn't be reporting, but we'd be monitoring and memorializing what's going on so that we could bring, more systemic change where we'd say, look, we need to invest in public transportation for those going to court. That's sort of the idea behind it. And I should also say, too, that we're kind of already doing this. And we're actually saying in court, and I don't know if Judge Lucas, we've been in your court, but we're working with the Public Defender's Office now and are just doing it. Like, so we go to every felony arraignment court. Every felony arraignment court in this county, you got a debug team sitting in the back. And we're at every bail hearing that we could go to. And the public defenders are saying, Your Honor, there's a change of circumstances. My client may have had a high bail, or my client may have had a failure to appear in the past, but now they're getting accepted into DBUG's community release project, which means they're going to be able to go to a meeting once a week, that they're going to have people calling them, giving them reminders. They're going to have a resource person navigating them to resources they may need, like housing and employment. And we actually are being donated through a pilot program, a technology of automated text reminders for court through a proven technology called Uptrust. Uptrust is so confident in our county that they decided to work with us to provide this service in a temporary way for free for anyone that the public defender and DBUG's working with. So we have all this stuff kind of cooking, and what I'm so anxious to get this off the ground. That's why I didn't want to wait for like an RFP.
If you're already doing it, then I'm not sure what we would need to do. So if that's a body of work that's already happening in collaboration with the district attorney's office, public defender. There was a little mishap there.
It's a whole different app.
That's right. That's a whole different app. Then I'm not sure exactly what would be required of the group, if anything, if you're already doing it. So, I mean, I don't know, Damon, if you want to weigh in on that, or.
I think part of it is that we should think about what makes, in particular, the court most comfortable in aiding their decisions. And certainly, I think we've had a long history of collaborating well with DBUG, but figuring out how we collectively can help the court support what the court wants to, or the decisions the court needs to make, and even in collaboration with pretrial services. So I think there's probably value to potentially maximize our impact, and we should continue that conversation, whether it's independent of this group or whether we convene some sort of other work group.
If you were already working on it, then I wouldn't want us to do anything. I don't want to impact that process. And it sounds like you need to work with the courts anyway. I think the other issue is a separate issue. It's actually something even that's got some different implications to it relative to technology and some other issues that I actually wanted to raise later in the meeting. But it sounds like you were already working together.
Yeah, if we could do, I guess we could do this totally independent of this, but if we did have a small group kind of running discussion, with.
I'm actually going to suggest something even more different, which is you already have a process and a program you're working on with the public defender, and I'm just going to suggest you keep doing that if that's what you're already doing. I think on this other issue, I think that is something that I want to give a little more thought to, but if you're already working with them, I'm not sure what we need to do.
Yeah, I would say if we could, definitely for this thing to really move, and we're already in conversations, obviously, with Aaron and Gary. I think if we all had the same conversation, public defenders, pretrial, and also we had a representative from the judges, if we could start brainstorming together, that way we'll all be on the same page.
But don't you? Maybe I'm misunderstanding. I thought you said you have a program that's already working.
Yeah, but we are. But I guess what I'm saying, there's like a Cadillac version of this thing that we could scale if we kind of plotted this thing out. So like one way to do this is if you give us 6 months and we just reconvene and you let us kind of do the thing that we're doing at the kind of scale that we're doing, which is admittedly smaller than what it could be if we had 10 organizations doing this, we could have Stanford or somebody just do a study to see what's coming up and what type of numbers it's yielding and what kind of support systems people need. We could bring those numbers back to this group, and if the numbers might say, hey, look, community release project is sufficient for people to make it back at a high rate to court and not reoffend, then this county could decide to say, look, we need to invest in this in some bigger way. Or we might say, hey, look, here's the impact of, this is why we think reporting conditions are needed in these incidents or something like that. So yeah, I would just say if we could, I would agree to say if we could hold off on re-putting out the RFP, particularly since no one applied for it, and then let us show some data on what's happening, then we could talk about whether we want to scale this thing or not as a county.
So, okay, so I heard that, and what I'm going to do is, I think this is one that as we finish the meeting today, let's come back on the next steps, and that'll give us a chance to all noodle on that. Okay. So thank you. Jeff, I'm sorry.
No, that's
you guys are all next to each other, so I apologize.
That's fine. I just have some concern, especially with the EMP program. I know that it's been implemented in Sacramento. The sheriff says it's abysmal. They've had some real serious problems with it. So I wish that we also look out and reach out to these other counties that have already implemented these systems and take a look at what's going on and what's happening and the problems, the inherent problems that they have. Also, Mike.
And that's EMP?
Yes.
Okay.
That's the electronic monitoring.
Yeah, and then David, did you want to come up here? Why are you sitting? Did you get in trouble? We can bring another chair up. Yeah, or even you can even make yourself at home right there. But so I think this might actually impact your thinking a little bit, or some work that you're doing. So I wanted to make sure you were sitting at the table. We can you're comfy right there, or we can bring up a chair. Okay. Yeah.
I tried to advise that he move up, but he didn't take my legal advice.
Oh, there you go. So, but anyway, so your point about the EMP just is that you in Sacramento County, they're not having success with it. And do you know why?
No, they're having some serious problems.
And the
high number of individuals cutting them off, escaping, and committing other crimes while they're out on electronic monitoring.
And do you know the population using them?
That I don't. This is just a conversation I had with the sheriff, and he is keeping the program on, but he says it's not working out well for the county. So I just wish that we reach out to these individuals or these other counties and take a look at what's going on and the problems, and make sure that we don't have those problems here. I attended, I don't know if you're familiar with the public safety meeting that happened in Willow Glen. About 400 people showed up. And for Willow Glen, that's huge. And it was a forum that Deb Davis put on, Councilwoman Deb Davis and the mayor, chief of police, a few captains, and the city manager, and showed up. People are upset what's going on in this county. They're outraged. We've had a dramatic increase in crime in this county. A lot has to do with some of the recommendations that were made here. A lot has to do with the city council and some of the state initiatives, whether SB 4757, AB 109. I don't know if any of us have read the Mercury newspaper, what's going on in Willow Glen. People are having their doors kicked in, having their cars broken into every night. I know this is a great thing, put people back out on the streets. But you see what's going on in this county? I know we think we can all fix it. You guys don't work in this business. I know there's a few of them. I know you work in the community. I know the judge deals with the courts. I know a lot of judges are not happy with what's going on and what's happening. A lot of them feel their hands are tied. Law enforcement, talk to the chief, talk to the Deputy Sheriff's Association. Their hands are being tied. And we're putting these people out on the street because it's a good idea. You take a look at SB 10, these individuals are going to break into your house and they won't be able to arrest them. They'll cite them in front of your house, only for them to go and to break into another home. We've seen some cases. New Jersey has done a similar to SB 10, but not as extreme. Call it SB Light, SB 10 Light. They had one individual arrested 82 times or cited 82 times for theft in a 4-month period. That's what we're going to see. We had another individual who was arrested 102 times, or not arrested, but cited. The 103rd time he killed a cop. I know what it takes. I have 160 employees in my company. I spend roughly $2.1 million just on investigations, on returning people. And mind you, I have offices throughout California. I'm only 5% of the bail in Santa Clara County. I know what it takes. And I think a lot of us say, hey, this is a great idea. But listen to these people that are being affected by these crimes and what's going on around these communities. It's appalling. We could talk to the lady who had a carjacking the other day in Willow Glen. We could talk about the elderly lady who had her door kicked in and stole her belongings while she's in bed. Or the hundreds of people who are having their cars broken in Willow Glen. I know we have to be very careful of what's going on, and I hope we're not at a point where we can't go back.
So are you good? I mean, for the moment, I want to make sure okay. So I wanted to go back just on, so you were at EMP home detention program. Did you want to say anything else about that? You want to jump in? I just want to make sure he got a chance to finish his report. Just, yeah, and then
So regarding the EMP, we had the Pew Research Foundation come in and study our EMP release population, and by the University of Ontario in Canada. That report is going to be released soon. However, what we found is it actually increased court appearance rates based on the study as compared to non-individuals on EMP. The new offense rate stayed statistically the same. However, violations increased when individuals were on electronic monitoring. So obviously they're under much more scrutiny when monitored correctly under a GPS system. So I will be sharing that report once it's published with everyone, but we were part of that national study and have our own local report on EMP releases. We also reached out across the state and country regarding electronic monitoring. I have concerns about net widening of throwing everybody on electronic monitoring, and it should be specific to an individual's risk and their charge. For instance, someone that may have been dealing drugs on EMP, they can still deal drugs in their home, but if they're there for a DUI, we can monitor them to make sure they're not driving using electronic monitoring. So it needs to be specifically used, and just so you know, the history in Santa Clara County in pretrial releases is a very small portion of our overall releases is on electronic monitoring. For instance, we have over 1,600 people out on pretrial release today, and only about 200 of them are on electronic monitoring. So we're very cautious in how we use that. This new program is specifically designed to give the individuals the opportunity to earn custody credits in the community, so they benefit greatly from this and avoid jail time. So we're going to monitor it closely. It's a pilot. It's only going to be 100 persons, and I'm sure David will stand up and be the first one to say if it's not working. So that's it.
Thank you. And then, Damon, did you want to make a comment? And then Chief Garnett. Chief Garnett.
I just had just a quick question, Raj, just so I make sure I understand. So you're talking about like 3 different ways somebody could be released, or maybe even forced. So like released outright, released under pretrial supervision, or released onto some kind of program where you guys would provide support? Yeah. Okay. Is that accurate?
Yeah, I think that's accurate. It'd be So there's OR,
Right.
and then there'd be a category, not really a category, but there'd be a pool of people where pretrial supervision maybe isn't fully required, but a judge wants a little something extra to feel confident that they'll return to court. So Community Release Project could serve that aim. And then also on the tail end, if SORP doesn't feel, if they want a little supplement to SORP, then that just says they could come to weekly meetings, then this could be an add-on or kind of partnership with folks that are on SORP too.
Yeah, that's what I was wondering, is if there was something out there about being able to release possibly higher risk below electronic monitoring. I agree with Gary, otherwise everybody gets put on, but have like a community-based agency augment the support portion and leave it as pretrial supervising, because it just seems like it would get through exactly what you're talking about. Like if you're the only ones looking at those folks, I can certainly understand the pushback about the non-reporting.
Right.
But if you were like the services support, then that kind of goes away if somebody else is responsible for the supervision part. So I was just trying to get clear.
Yeah.
I'll just make my comments somewhat brief, but I think, we've spent the last several years in a lot of criminal justice reform efforts, and it really is important that when we discuss the progress and reflect on it and make decisions, we're doing that from an informed position. And, in particular with SB 10, let's be clear that my understanding is it eliminates people being eligible for release for serious and violent felonies. If that's the situation, people who are charged with carjacking are not eligible for release under SB 10. People who are charged with kicking in people's doors and going into their homes, especially when they're home, are not eligible for release. And so I think it really is important when we discuss any criminal justice reform, and in particular something like SB 10, that we're being honest about what it does and does not do. I think Raj has made some points about the concern that there is a lot of flexibility and calibration in the system that could result in actually more detention rather than less detention. Because under the current system, someone who does kick in a door or who does carjack is eligible for money bail. So that's what we really also need to discuss when we're having these conversations.
Thank you. I'm going to let staff, so I'm going to take one more comment and then I'm going to let staff finish, because one thing, well, anyway, go ahead and make your comment and then I'll make mine.
No, and all due respect, counsel, I would, agree to disagree. We see where this morphs. We see where it is. And we see some of the problems that are going on currently in other states. I've read the law, and I'm sure you have too. There's a lot of people who are going to be released out on the street that should not be released. Another couple of issues are the constitutionality and the issue of individuals who are given a right. Somebody is accused of raping somebody, they will not get out. They will be held in custody until that case is resolved. And I know that's an issue with the ACLU if somebody's accused. So
So here's what I want to recommend. Jeff, I want to let the staff walk through the report, and I do appreciate your position and your comments. The one thing I was going to actually make a point of is saying that I think I have, and I think the group has tried to use as much as possible the actual numbers that we're seeing here in the community, and really being able to examine more carefully and more quickly how trends are being impacted by actions we're taking, by actions others are taking, by the economy, by any number of issues. And so what I'd like to do, if we can, is let the staff kind of complete their report. I do want to go back and talk about some really critical issues, because one of the issues I'm really concerned about is this issue of how we quantify what we're seeing in the community in a meaningful way. And anyway, so if I could ask staff to go ahead and finish the report, and then we'll go to comments and next steps, if that's all right.
Sure. I wanted to just quickly highlight some of the impacts of SB 10. Obviously, it's a big body of legislation, so I just want to highlight some of the changes in our county once it's implemented.
Wait. I'm sorry. Can you go back one slide?
Sure.
So can you finish these? Can you finish talking about them? Because like the Odara tool, do you mind doing
Okay.
those?
No,
I wasn't trying to speed you up. I was really just trying to make sure that you guys got a chance to go through all of this.
Okay. I did go through these already, but I'll do
Oh,
it again.
did you? I'm
Yeah,
sorry.
It's all right.
I'm so sorry. I didn't hear Odara. That usually catches my attention. That's okay. Go ahead. Sorry. Go back.
Want me to?
Nope. No.
Okay.
I just wanted to make sure you talked about that. I apologize.
So one of the biggest impacts on our county is the court will now be picking the pretrial risk assessment that pretrial services uses in the county. The court also now will contract with a pretrial assessment agency in Santa Clara County. There's an exception made in the legislation that it will be pretrial services to continue to do those assessments for the court. We do anticipate increased workload for the DA and public defender regarding the potential preventative detention hearings. SB 10 moves to a system much like we have in juvenile already, where individuals will have a detention hearing similar to that and make decisions. And so that's one of the big changes right now is there'll be a official court hearing talking about individuals and detaining. The DA will have to file a petition to detain someone in jail, and they'll get a hearing and be represented by an attorney. Again, very similar to what happens in juvenile now. We do think there's a potential increase in pretrial release population, possible impact to the Office of Pretrial Services workload. The reason we say that is a lot of people have stated that SB 10 has the potential to increase the amount of preventative detention that takes place. However, the Judicial Council's estimating statewide an increase of the release population by 125,000. Mainly, many counties in California still detain individuals on misdemeanor charges currently. And under the new law, most misdemeanor offenses would be have to be released within 12 hours of arrest. So we do think there is in our county potential increases in the release population. It eliminates monetary bail, and it also provides state funding for pretrial assessment and supervision services. Currently in our county, that's all paid for by the general fund. However, now the funding will come through the Judicial Council and be contracted by the local judicial court for those services. Next slide, please. I should also mention one thing that's not on the slide that I think is crucial for this group to hear is one of the other major impacts of SB 10 is the victim notification piece. Victims will now have a right to weigh in on detention hearings and give input to the court, and the DA will be responsible for contacting those victims before release decisions are made. So that is a new impact that enhances the victim's input into release decisions. All right, next slide. A couple other items I hope to get feedback and direction from the group on today, and we've talked a little bit about this, possible modification and reissuance of the Community Bail Fund and Community Release Project RFPs. Issuance of a RFP for an independent study comparing outcomes by release type. When considering the potential impacts of SB 10, is this something the group still wishes to study? Further data collection on the commercial bail industry on bail performance outcomes. To date, we have not received any data in this county, and is that something the group still wishes to go forward with? So with that, I will end our presentation.
Great. All right. So maybe if it's okay, if we can take these one at a time. I know they're a little bit linked, but this just sort of speaks, and let me just start with setting the table a little bit for this discussion. have been really both impressed and just really intrigued with the work that the county's been able to do with the city of San Jose, in particular around youth. And the probation department has been very rigorous in taking a look at issues and trends as they emerge, working with departments that are most impacted. The city of San Jose has been the most impacted, primarily just because of how big the population is, but allowing us to take a look at trends, in some respects responding to very broad statements, right? People are nervous and or worried about, a spike in crime, when in fact what we may be talking about is a spike relative to a pretty small statistic overall, and then we're really looking at a handful of young people that we need to address very specifically, and looking at methods for doing that. I say that because I've been so excited about the work that we're seeing come out of, really actually out of your shop with your research team, that it's made me feel like we have such a bigger population with the adults, but that we have to figure out a way to really get our hands on the numbers so that we can do an even better job of determining what we're doing at a local level that is having a positive impact or a negative impact, and being able to course correct on that. I say that because one of the reasons I was most interested in us issuing the RFP in the first place is I thought that would actually be a very powerful and much quicker way to aggregate data than the way we do it now. Because the one challenge we have now is that we're looking at data that can sometimes be months behind. And really what I'm interested in taking a look at is whether or not we can get into much faster set of data, and then be able to dive deeper down to be able to understand what we're seeing happening on the ground. And let me just put a point on this, that I know, all of us, that when things get reported in the paper, they're stories, right? They're stories, they're anecdotes that then drive our behavior instead of us looking at what's working on the ground. And that's really what concerns me as we're starting to make these big changes. So one of the reasons I wanted to have staff finish having this conversation, and not just with Raj, but even among yourselves, is I am worried that, not worried, but I feel like we're getting introduced to so many apps on a daily basis that there's one app here, you're using the pretrial services, Aaron, you're using data, you all are using data relative to youth, and I'm feeling like we're data in, oh my goodness, I don't know why, there's a lot happening in the world right now. And all of it on my phone. But anyway, that there's, that us getting a handle on what we're collecting, why we're collecting it, and then how are we using it is really important. So I was really excited about the RFP and I see issuing an RFP to do an independent study. I think that's a really good thing. But I'm also looking at how do we get more real-time data? What is the best method for doing that? And how is that happening cross-system? Because I think one of the big questions is, how do we compare one approach over another? And really, I still don't know the answer to that. And those of you who are steeped in this and who can look at lots of studies, great. But the public's not looking at studies. They're looking at stories on the evening news or in the Merc, and then we don't have a story. In fact, we don't even have really clear data. I mean, we do in some instances, but not overall. So for one, I'm really interested in issuing an RFP, but what I would be wanting to better understand is how that RFP gets connected to the entire system so that we're really able to look at it in a much more comprehensive way than I feel like we can do now. So that's box 2. I don't know if anybody wants to take box 2 with me and give feedback on that, or concerns about what I've just said.
No, I don't have any concerns, and I think you actually, I think we could get that. We've got our director of research came from a nonprofit research firm that did very similar work to that. I think is where it gets complicated, and I think we just need to have a body of people, or I guess the board, who makes decisions about really what you're looking at and why you're looking at it. Because when I hear like somebody's been arrested or cited over 100 times, that just sounds crazy to me that we would continue to do that. Like, that could be legislative, it could be, I don't know what it is, but I think we have to have like nuanced ways of looking at, it can't just be, did they recidivate or didn't they recidivate, or did they show up for court or didn't they show up for court? Like, did they not show up for court but then come back later that afternoon? Because we had a way for them to come back later that afternoon, for example, because that's a big thing. Somebody absconds and then they have nothing to lose, so they kind of go on a bender. So I do think we just have to, some group has to agree on how you look at that so that everybody trusts it and they don't say, well, that's, that's BS, because you can look at similar data differently. But I do think frequency of offenses, showing up for court, severity of offense, those are just huge. Because if somebody does something 100 times, we should be concerned, but we should be way more concerned depending on what that behavior is, right?
Mm-hmm. So I'm going to just leave that one, Gary, if that's enough information. And then I want to go to this second one. And this is where I want the first one. And Raj, this is where I wanted to further engage what you were talking about earlier. I think in some respects, just hearing what Raj just said, and actually, Laura, what you pointed out, like, under what terms and conditions are we attaching community support? And I just want to tell you initially what I was thinking about, which is why I was not concerned about people saying, look, the person's not showing up and here's what we think is going on, is that I actually thought that in some respects having meaningful communication between the nonprofit partner and the courts, or the nonprofit partner and pretrial services, was actually part of helping support the person. And so when I saw your notes about, well, this may be us, creating conflict with the community we're trying to build trust with, then it felt, as I was listening to you, like two different outcomes. And so I'll tell you what I wanted with the oversight. I actually think that the issue about whether or not we're putting too many conditions or whether or not we have surveillance over a certain number of people is something I know the county is really sensitive to. And by that I mean really the staff in many ways, and I think some of the board. Where I was looking at this is I thought for some period of time that may make sense for us to do, in part as we're learning what about our systems provide the appropriate level of support, while we keep systems in place that both give the courts and give the community the comfort that we're moving in the right direction. And why I understand the point you raised about SB 10 being too, like, in the end, it feeling like a different bill to the advocates. For me, it made total sense to me that we are moving down a continuum, and that we need to do that, bringing, frankly, when you're fighting for justice, you got to overstep your bounds, and I get that in from the perspective, Raj, of the work that you and the ACLU are doing. I think from the concerns I have was really rooted in the kinds of crimes where I think families can be enormously impacted. And I was really thinking a lot about domestic violence, and I was thinking about how our systems really don't know how to respond to that as both as a crime or a social ill. No system responds to it well. So what steps can we take that support families going through that process in a way that does both bring justice and public safety? And I don't think we know, which is why I was particularly interested in us having a lot more support for people who were going through those kinds of processes, because sometimes they get pled down. So anyway, that's part of what was going through my head. And then the other was around folks who have really, frankly, some mental health issues and some drug addiction issues, because I've been listening to Judge Manley quite a lot about how people just can't get back to court. Like, sometimes they do need a second day, and we got to figure out how to get them there. And and what that may be a reflection of is a mental health breakdown, not necessarily a criminal behavior. So, but if there's no communication, if you can't say, no, the person's not showing up, and we're going to go try to get them, and here's what our plan is, and then how do we do that? So what I would just say to the staff is, if there's a process that's already going forward with the framework that Raj has laid out, I want to encourage you all to finish doing that. On our end, I think we need to present, if we're going to do another RFP, I think we need to present it back to the board with what the options would be in the RFP, so the board really can make a policy decision about, yes, we mean to do this, or yes, we mean to do that. Because I think that the board, I can't speak for everybody, but what got presented to the board is actually what you put out. And so I do think there was a level of comfort, and we didn't have, at least to my knowledge, any concerns raised when that came to us by any of our public safety and justice partners. I mean, outside of one that I think we then were able to have a conversation and remedy. So it wasn't like we were doing something that people felt was not a good step. And so I want to make sure that we're really being community-minded community in terms of making sure all of our partners are bought into each of the next steps. So that's really what I would ask, is that we split them, let you all finish the work that you're doing with Raj, figure out whether or not there's a point that we can do some reporting. And I think your point about getting the right data is right, but then bring this other issue back and give the board the options. What do you think, Gary?
Yeah, I think we can do that, and I'll work with council and our work group on that, and we'll have further conversations, obviously, with Raj and on that group. One of the I'm all in favor of any kind of support we can give individuals in the community, and that the court can use as another tool in their toolbox. However, I am concerned about information sharing, and I do want to talk to Raj and counsel about that and how we can legally share criminal justice information with a non-public safety entity. And I also, just so you know, pretrial can't refer anybody to anywhere without the court ordering such a service. So I really want to make that connection and loop everybody in and have those conversations before bringing anything back, if that makes sense.
Which totally makes sense. I think those are conversations all worth having, really down to a pretty detailed level. Yes, Raj.
Yeah, I would say I'm in agreement with us, trying this thing out and seeing where it goes and seeing the impact and seeing where the holes are and that kind of thing, and be able to present a data set back that shows some comprehensive picture, rather than anecdotes and that kind of thing. And what I'd say for the pretrial release project that we've been talking about, the community release project, is I think the more familiarity like the local court has, the better. And what it's going to need, and this is going to be what SB 10 hinges upon anyways, is going to be the judicial discretion. Gary and I have talked about this, and we can make all kinds of decisions in here, but it's that building next door where ultimately that decision has to be made. So I think the best way to do it isn't just to say, well, take Debug's word for it, or let's just see what happens. I think it should be an identifiable pilot with identifiable markers to examine, and that could roll us into what was the second recommendation, this idea of an RFP to do some evaluative study about the different release options, because right now we can't compare it if we haven't done it. So I would suggest that there's an order, that we do this thing for a while, we pilot it, we get some numbers, and that way we could do some comparative analysis of the community release project versus pretrial services supervision versus electronic monitoring versus detention. But I think you need some numbers to then do analysis on. So I kind of see it as a 1-2 step. I don't know what other people think.
Yeah, I think actually it may be concurrent because we already have programs in process.
Well, you have programs in process for the other ones.
Yeah, but I guess my point too is that the whole system needs to have a stronger set of data. So when I was looking at number 2, I was thinking about it for all the different parts of the system.
Yeah, that sounds cool. And then we could use that as the kind of baseline to look at the impact of the community release project. The other quick question I had was independent of that was the bail fund, the community bail fund RFP. So, if Jeff doesn't get his votes and SB 10 passes, what then happens with the revolving bail fund?
I actually think, I'm going to tell you my opinion about this, because what I think happened was at the time that we were coming up, yeah, you guys are going to have a bet. But I think what happened when we brought all these recommendations forward, this was so a lot of different activities that we thought we may be piloting even having that community bail fund. It seems to me less necessary now than we thought it was at the time. And so I would actually, and I think that was confusing, because I think the other thing is we reached out to people and said, try to fix 3 or 4 different problems for us, and one of them was the bail fund. And so what I was going to recommend is that we actually that we do another RFP for the service part of it, but remove the fund, because I don't think the fund is necessary. At least that's the way, but now if SB 10, so I also realize I'm saying that at this moment in time, and that the idea came up a while ago. But it always felt a little redundant and a little awkward. It's just we were looking at it for another option.
I just have a suggestion. Why don't we just put that one on hold till we find out the outcome of SB 10, and we can revisit it if things stay the way they are. That's kind of my suggestion.
Yeah, I think that makes sense.
And again, to what County Council was talking about, the other big thing that would certainly inform what happens with SB 10 in practice, even if it does come into effect, is the Humphrey decision. Because a lot of what the Supreme Court's going to decide is the scope of preventive detention, of an expanded view of preventive detention, which is what SB 10 essentially is based upon. But if the Supreme Court has a higher, more narrowed interpretation of the California Constitution of Article 1, Section 12, it limits who could be preventively detained. And if you have a narrowed scope, then the rest of who's high risk and automatically preventively detained goes away. So there's a couple balls in the air that, to Gary's point, make a lot of things really hard to figure out.
Jeff?
You were briefly talking about the cost and the funding to increase this supervision. I know that the federal system in Washington, D.C., they manage a pretrial release, they have a population in Washington, D.C. of roughly 700,000, which is roughly a third of Santa Clara County. And they release roughly 6,000 inmates a year at a cost of $63 million, and that's their pretrial service. So we're looking somewhere, what is that, $118 billion to manage the new pretrial release service. I don't think we realize how big this is. And these are figures.
You know what? I'm not sure I understand what you're saying. Are you saying that
Washington, D.C. runs a pretrial release service, federal system. The population in Washington, D.C. is roughly 694,000. They spend $63.5 million on their pretrial release. If you take it based on the population for Santa Clara County, that equates to roughly $118 million to run.
You're talking about the federal system?
Their pretrial release.
For the federal government?
Yeah, because Washington, D.C. is a federal district. They don't have state jails. It's a federal jail. And they have a pretrial service. That's what it costs to run it.
Okay.
So you're looking at SB 10. They equate that SB 10 will cost roughly 3.5, close to $4 billion.
And when you say you mean the Bail Association?
Bail Association.
Okay.
If you take that number, you take that 63, you know, base it on the population of the state, that's what it's.
I'm sorry, I wasn't getting the connection you were making. I'm sorry. Gary, did you want to?
Yeah, just to clarify, Washington, D.C. Pretrial Service Agency is probably the most renowned pretrial service agency in the world, frankly, and they're way, in my opinion, over budgeted for the numbers they serve. For instance, their caseload sizes are 5 to 10 individuals per officer. They have a whole research and data division of about 30 staff. So it's situated much differently than our pretrial services agencies in California, and much different where most of them are done through probation. Those costs are already there. So I hate to say that it's going to cost we also don't supervise as many people as they do. They supervise just about everybody in Washington, D.C. pretrial. So most of these individuals, especially the mandatory release under SB 10, will not be supervised. They'll be given reminder calls for court and so forth. So I don't know if those estimates or comparison between us and DC, a federal agency versus county local jurisdictions.
But I
is a
do
good
think
one.
the numbers, I mean, I think what you're raising is how do we look at all the numbers, right? How do we look at money? And that actually brings to the last recommendation you had. My question is, because on this it had further data collection from the commercial bail industry on bail performance and outcomes. And I'm wondering, did we actually ask for that information? And did we ask, who are we supposed to ask, and why don't we have it? And so,
My recollection on this is that we had this conversation at the prior bail and release work group meeting, which I think was last October or last September, and talked about the need to have apples to apples data comparisons between pretrial services on the one hand and the surety bail industry on the other hand. And statements were made both by Mr. Stanley and then, if you can remind me of the name of the other gentleman who was here from Aladdin, I don't recall his name.
Mr. Lacobe.
Yes, that they would be willing to share their data. And I think the means by which that was going to happen was through this independent data consultant that then the county has not yet pursued. So I'm not sure that any collection has already happened. I don't think it has.
because we didn't hire anybody to do that?
Right, because it was not going to be done internally by pretrial services or by other staff, instead through an independent data consultant that has not yet been procured.
So here's one, so let's make sure we do that. And then, but the other thing I was going to suggest is that, Jeff, there was another person who I apologize, I'm not remembering his name, but he was a statewide representative from the...
Popo?
Yes.
Padilla?
Yeah, because he also seemed very open to information and data sharing. But what I would just recommend is that if we reach out through Jeff to them to find out, they may even have some recommendations about folks who've done that kind of research for you in the past that we could have a conversation with. That would be ideal.
I know a lot of these figures are already available. I mean, the county has it. I mean, the amount of individuals that we bail, the amount of money that's taken in, things of that nature.
I don't know who does keep that. Would that be the clerk?
A county clerk.
County clerk.
Yeah, it's actually, it's on it's even posted online. You can see the amount of bails that are written and court clerk, I'm sorry.
The court clerk. Oh, okay.
Sorry. Thank you.
Maybe what we can do, Kavita, is let's take a look through the presiding judge at what the court has available. And I know you have a new administrator now who's got her sea legs under her, because I do recall that one of the challenges was how that data was being collected and then how quickly it could be posted is just an issue that's not your issue, but it was an internal issue that the courts were having for a while in terms of data collection. So maybe we can talk to the court clerk as well, and then we can talk to Topo as well.
Yeah, I just want to make a quick comment that I know that the people will not be watched as closely as Washington, D.C., but Washington, D.C. has a higher crime rate.
Yeah, thank you. Go ahead, Kavita, were you going to say something
Yes,
else?
just one sentence. So in addition to the data that the court may have, and I'm happy to work on following up on that, about amounts of bails posted, I think the critical piece that we had talked about a year ago was outcomes. And that's the data that's hard to collect in really any other way than directly from the individuals who are providing the services.
Well, and I think and this goes back to the point I was raising about the system, like there's so many moving parts to it that following a person through it and collecting the data that says they came in this door, they then had these processes attached to them, then this is what the outcome was. I know that it's something we've been working with, even with the reentry center through Javier, on looking at how many people reoffend, how many people stay with the program, looking at dosage. And I know you all have got a head start on all of us in terms of thinking about this. So I just really want to encourage staff. And Gary, now that you have all of these under you, this may be the one opportunity we have to actually to really take a look at how we invest in this data collection, and then how do we show it in a way that really helps both us as decision makers and policymakers and the public understand how the actions we're taking are or aren't impacted by the programming we're putting forward. And then we can stop doing the ones that aren't effective and start doing the ones that are, and take a look at that. Okay, Kavita and team. And is it Adriana? Thank you. And Adriana, anything else you wanted to add?
Not on our end.
Okay, so does the staff have everything they need from us? Okay, Raj, do you have another comment?
Two quick
Okay.
things. Just on the data collection, because I definitely feel the same way that we need some numbers and need to look at it and drill down. And I know with pretrial and county council, we've been talking about some of this stuff too. So just to offer up, Civil Rights Corps, who's been looking at bail and release nationally, is very interested in working with us in our county to see kind of where we're at, and so they've been giving us some good discussion points of like looking at what Kavita was talking about, like not just how many people say are in a jail a night, but looking at how many people are incarcerated while their case is resolved, for example. That was like a question that having someone that's looked at other counties, then look at our county, it gives us something to compare to. And I know the folks at Civil Rights Corps would be happy to partner to get this information or do some analysis for us, and I could connect them with whoever to do that. The second point is, you were talking earlier about maybe having kind of smaller drill down discussions. SB 10, if it does happen, it will either become a thing where we're on our heels and essentially just waiting for a couple of years to see what will happen and then recalibrating to get to where we want our county to be, or it could be something where we could use our time right now up until October of next year to get in front of, to say, okay, this is our understanding of that law, this is what the landscape will look like, but what does our county really want in terms of an identifiable goal for pretrial justice? How many people we think is tolerable to have inside our jail? How many people we think is tolerable to be out on supervision? How many people think it is tolerable to be out without any conditions? And we should identify some goals, and then we should talk then as a community about how we want to interpret SB 10 to make it match the values and ambitions of our county. So I would suggest that we have a small group discussion, because each of us could play our part in then setting the terms of how this plays out. The district attorney's office could decide when they're challenging, when they're asking for preventive detention. Pretrial service could say, here's where we have the most impact. Judges, of course, have such a major determining factor in this. But I think instead of being like every other county and just waiting for October and saying, let's see what happens and react, I said we use this time to get in front of this thing and start brainstorming and taking ownership of the process rather than being the recipient of it.
So let me just make an observation, and then Gary, you can jump in. I think, so one thing that I think we're trying to figure out is, let me back up. I think that the question isn't how many people is it tolerable to have in jail, or how many people is it tolerable to have out on bail, or any of these other. I think we really have to look at the crimes that we're talking about, and not try to look at hitting a number that's arbitrary, because I think part of understanding programming, understanding our investments, really, it will help us to understand what kinds of crimes are being committed. And I think one of the things that the juvenile justice world is really doing a really good job at is taking a look at understanding that at a deeper level so that we can do some preventative work, which I actually think is a really big part of what we need to be thinking about. The second thing I'll say is that as part of the re-entry network, we've been thinking hard about how we get in the no-entry business. And so there's a lot of work being done right now around how do we take someone who's primarily mentally ill and get them connected to the right service. Like, how are we doing that on the front end? So we're even going back further, Raj, than the point that you're raising, which is, I think, the right questions we need to be asking. I think as it relates to bail, I think that if the work that was listed out on this list gets started to get dealt with now, I think some of the direction and some of those questions are starting to get answered based on the way we're treating people now and how we're supporting them through the different kinds of processes they're going through, whether that's AB 109 or people that we're deterring, or people that we're trying to get out who are in custody now who really just need drug and alcohol treatment. Like, there are a lot of things happening in the jail that may be one of the things we need to think about and maybe Gary, this is something you can give some thought to, is how we do, for lack of a better word, sort of a seminar for interested parties in the work the county's undertaking right now, where we see results and where we see holes, because I think that might help you help us think about how to draw those alignments in a way that may be more clear for us in terms of what are the next steps. But I would actually say none of us are waiting for SB 10, and that's part of the reason what I asked the staff for a report on is, irrespective of those things, what are the opportunities that we have to be pursuing right now? Because I think the real critical question, at least this is something that I'm starting to think about, is just what's the infrastructure we have to support the folks that are in our system, and so many of them inappropriately, especially as it relates to mental health, which we're working really hard on expanding. And then the other thing I'll just share with my colleagues here is that we've also brought forward a number of opportunities to start to address domestic violence. And part of the reason I was waiting for Ojara, and I'm sorry, I think my phone was having a conniption, was that, I also want to take a look at what are the next steps relative to DV. So we'll be bringing back on November 6th some recommendations for funding for actually studying the programs we have now, for example, for anger management, which I don't frankly think a lot of our programming is working. So let's study it. Let's be able to give feedback to the state so we can actually have programs in place that really do help people not go back and harm their families. Another thing we're going to take a look at, which will be a little controversial, but we're going to be working with the district attorney's office, really leaning, David, on your team to help us think about right now, when someone commits an act of domestic violence, we throw them in jail, but as soon as they get out, they go back home and the family either stays or they're displaced. So the question is, do we take the one person, put them back in the house and try to find housing for 4 people plus get them close to their schools, or do we find alternative housing for him and leave them in the household? So those are all like really, important things for us to figure out. So I think we're trying to do all that at the same time. But we should think about this. We should really think about how to get all our partners together, because they're on 1,000 committees, but I think pulling all those strings together, to show people the picture of the work that's being done, I think would be really helpful. Because I think it's kind of overwhelming for people who aren't you or you.
The other thing I'll just add, and I also think we need to do a better job including law enforcement in this. They're not here today. They have, just from our experience with changing the cite and release policy and what happened there, they need to be involved in these discussions as we go forward and have critical input. So this is another thought.
Yeah, and let's give some thought to the best way to do that. It's something, actually, we had a meeting recently, maybe it was yesterday or the day before, trying to think about, Javier, in your absence, about what should be at reentry versus all the other places it's at, because in some ways we have a lot of meetings, which I think are pulling people in 1,000 directions, because we all want to make the system better, but pulling it together in a way that's really manageable for all of us is something we got to figure out, because we want to be urgent and manageable at the same time. And I usually choose urgency over manageability, but I'm recognizing we're at a place where we have to align that. All right. David, Maya, is that what you were trying to tell me? Yeah.
So I just wanted to chime in to say quickly, I agree with actually many Raj, you should know, we have actually a working group that I confused this meeting for, which is why I was late. I'm sorry. But that is talking about just this issue. We don't want to wait. Look, SB 10 to a great degree was based on the work that we were doing here, right? But we want to work to move this forward irrespective of what happens, because really we don't really need the state to act in order to make decisions on a county of what we want to do. I completely agree, like we want numbers, but of course the DA's position is, hey, we want the right people in jail. We don't have some magic number it's got to go down by or go up by. It's like we just want to make sure the right people. Now, I kind of respectfully disagree. I do think SB 10 actually does take, it says in there it has to be consistent with the Constitution, and I think that the way it's going to be interpreted, as it should be, is the people who are detained are only those that, there are certain showings that are made that there is no reasonable alternative to protect the public. So I actually think it's a far more, what's the word I'm looking for, restrictive standard on detention than our current standard, which is basically whether you can pay for it or not. It's not quite that simple. But I do think as many of you know from other times I'm here, I'm often sometimes saying, hey, this is going to be really hard, this is going to be really hard. I actually do not think this is going to be such a hard nut to crack. I mean, I'm really encouraged by DBUG's participation in this, but we have models for this from all the years in the trenches in Judge Manley and other courts, like where we use community groups to leverage the supervision that pretrial services or probation can give. And we only give them the information that is appropriate, for them to receive. So we don't have to reinvent the wheel. We've done that. I really want us to collect data. I think your idea is brilliant, Supervisor Chavez. I really support it. But for this problem, we should collect the data on all this. But remember, to improve on the situation we have now, we have to track what offenses they commit between being released and their trial, right? We don't have to figure out for this what programs work to really heal someone so they don't commit crimes again. That's very important as for no reentry for long-term solutions, and there's certainly a synergy as we begin to work on all these problems separately. But right now, most people are not booked into custody. Of the people booked into custody, I think most get out either through pretrial services or through bail. It's a very important change, and it connects with other things, but I don't know. This is one where I'm just optimistic. I think it's not going to be nearly as insolvable as we think. And by the way, I talked to a colleague of mine in New Jersey, and who works in Newark, so some pretty hardcore crime, and he just in like 5 sentences, fellow prosecutors like, this is the deal. This is what you're going to see. Gangbangers, serious crimes, in general, they're in custody. Quality of life stuff, in general, you have to deal with them through pretrial services and probation. Thought it was going to be terrible, don't have any problems with it. And this is like a career prosecutor. So I've never felt this is the insolvable problem that, our dealing with mental health systems, that's not insolvable, but that's a real challenge. This, I just think we're going to be able to do, and I think we're going to be able to do it we're going to be great progress prior to however this shakes out with, whether I don't know if they're still going to take Humphrey or not take Humphrey, but whether they take Humphrey, I just think we're going to be ahead of this. So anyway, since I am often kind of the naysayer, and here I'm like the one Pollyanna in the room, I thought I would revel in that new role and just be able to say this is going to be fine.
So you get the last word, except for Jeff. Go ahead.
Well, he was going to just say the same thing, so don't worry about that.
Slightly different. I would beg to differ about New Jersey. They've had a dramatic increase in crime. I would love, if anybody would like to share their email with me, I would love to send you the information that I get constantly every day, and if you want me to knock it off, I'll not send it to you. But I have already had thousands of emails showing individuals that are out committing crime while they're out on pretrial. It is devastating. Also, the dramatic increase in costs, because they said it was only going to cost this much money. It keeps going up. I have a letter I'd love to share with everybody from a Democrat assembly member that voted for this bill. And he sent a letter to our legislature saying, please do not pass SB 10. It is devastating. It is crippling. The cost is outrageous, and the dramatic increase in crime. So I'd love to share. That's not coming from me. It's coming from an assembly member who did vote for that bill that increased their pretrial release. I hope we really look at these numbers and look closely, because it affects everybody. Like I say, I live in Willow Glen. I see how it just. I know Santa Clara County in the last year has had a 10% increase in property crimes. I just got the report from Department of Justice. And I'd love to share that information with all of you. I'm sure some of you already have it. But I would love to share what's going on and what's happening. If you'd like, if you guys would like to hear it,
I think that what we'll do is we'll make sure Maya gets connected to you, and we can get it out to the whole group. So anything you want to put together. All right. Well, I want to thank everyone. I think what we're going to do is I'll work with staff on when we should do our next follow-up. I am going to recommend that staff consider doing follow-up prior to something coming to the board for next steps, just because I think it's good to vet it, and it gives the public another bite at the apple, which I think is really important for transparency. I apologize. The room is so warm. For anybody who's thinking they're getting a fever, they're not. It's just toasty in here. So thank you. Have a good rest of your Monday.
Oh, don't apologize at all. I was the one who was late. I just, you know what? We have another thing by the same title on Wednesday.
The reentry group, that was the one that, like, I
No,
saw
no,
your
yeah,
name
there
on
was
the
that
roster, and then this one
reentry.
I didn't. I know
You know
you're
what?
related and involved, but
Who knows? Honestly, I could take a dart. If it had the word reentry, mental health, and bail on it, throw it at, I'm probably supposed to be there, but
Yeah,
you know,
right.
can't tell. So don't